Good morning. My name is Lucy McCann and I'm a partner in Brodie's Restructuring and Insolvency team, and I'm delighted to welcome you all this morning to the session on ESG and restructuring, how to be sustainable when dealing with stress. I think you'll have to be living under a rock not to know that in Glasgow we're hosting COP26. In preparation for COP, here at Brodie's we've been considering the importance of ESG matters, how they affect our clients, the sectors they work in, and the regulatory framework within which they operate. The Restructuring and Insolvency team is no exception, and as a team we've been thinking about how ESG affects the work we do and how it could impact on the restructuring mandates that we will be working on in the future. A little bit of light Googling will show you that ESG and restructuring are not a combination that have been given much consideration to date. Are we the trailblazing Greta Thunbergs of the restructuring community? We'll let you be the judge of that. Now, I'm conscious that we only have 45 minutes for this morning's session, and ESG covers an awful lot. So we plan to just highlight the matters that we think are of interest, but today's session will really be a canter through. So we're going to start with some basics. What does ESG stand for and why is it relevant to business? So ESG stands for Environment, Social and Governance. ESG credentials of a company are not just about what the company says about itself, they are now measurable and can be determined by third parties, independent companies, and also by research groups. Now, breaking these factors down, environment. What kind of impact does a company have on the environment? This can include a company's carbon footprint, which is very topical at the moment. And if the company, for example, uses toxic chemicals in manufacturing processes, or what its sustainability efforts are making up its supply chain. For example, have they ditched plastic and are using paper in their packaging? Social, how does the company improve its social impact, both within the company itself, but also in the broader community? So social factors can include everything from LGBTQ+, equality, racial diversity, and inclusivity programs such as apprenticeships. And we'll look at how the company advocates for social good, not just in its own business, but actually in the wider world. Governance, how does the company manage and drive positive change? Governance includes everything from issues surrounding executive pay to diversity leadership, and how well that leadership responds to interacts with their shareholders and stakeholders. For me, ESG ultimately boils down to stakeholder engagement. How does the company treat its workers, communities, customers, shareholders, and the environment? Now, these things might feel intangible, but there are indexes which measure companies' ESG credentials and they report back to markets. Stakeholder and investors are becoming increasingly interested in these issues. It's not just about the company itself. ESG affects the supply chain, and this was very well illustrated actually last September when Sunday Times investigation found that a Leicester factory supplying Boohoo had been paying workers just £3.50 an hour, and they failed to follow the COVID-19 social distancing rules. Boohoo shares lost half of their value pretty much overnight. Now they have since recovered, but Boohoo was also dropped from ethical funds, and their stock was also dropped by major investors. Now, we know that Boohoo has had the financial strength to survive the reputational damage caused by that particular investigation, but you can quite see that if others do not have that same financial strength, that they might not find themselves in such similar circumstances. Modern slavery is also something which is on policymaker and lobbyists' agendas, and many of you will be familiar with the modern slavery statement that requires to be made in audited accounts. Now, in the summer of this summer, a private member's bill was tabled, which, if enacted, would make it a criminal offence for a person to be a person responsible for a modern slavery statement, including all directors, to knowingly or recklessly supply a false or materially incomplete statement. The bill, in terms of the penalties, is suggesting that it should be a 2-year imprisonment for individuals who make that false or misleading statement, and a fine of up to 4% of the annual global turnover of the company, capped at 20 million. And the only defence would be that the person was not guilty, they took all reasonable steps to ensure that the statement was correct and informed the independent anti-slavery commissioner as soon as practicable. Now, this is a private member's bill, so it's unlikely to become enacted, but is this the direction of travel? As ESG becomes a higher priority for stakeholders, it comes higher up in the political agenda. So I think that there's going to be plenty to look out for. And in this morning's session, Shirley Li-Ting, a director in our restructuring team, will be looking at the lender-investor attitude towards ESG considerations. And then we'll be hearing from Elaine Peterson, the partner who heads up our real estate restructuring team, about how ESG is impacting the real estate market. So without further ado, I'm very pleased to pass over to Shirley to look at the lender considerations.
Thanks, Lucy. Not so sure about being Greta Thunberg, blah, blah, blah. Morning, everyone. As Lucy mentioned, ESG considerations are important even in a restructuring scenario. And this is the main message we want to get across today. So I'm going to cover how the attitude of lenders to ESG, lenders and investors to ESG considerations can potentially impact a restructuring scenario. I'll also say a wee bit about what the current ESG landscape looks like, primarily from a funding perspective. And I'll finish off with a few thoughts about what the future may bring. So needless to say, when we think about restructurings and distressed companies, ESG considerations don't immediately come to mind, but funding and therefore the attitude of lenders and investors towards ESG risks are relevant. As typically when we're advising distressed companies, the options we would normally look at are a refinance with existing lenders or new cash from new investors. At the same time, we would look at the potential of a sale of the business or only part of the business through perhaps a pre-pack or otherwise. So in terms of current attitude of lenders and investors, what we're seeing is that they are starting to take into account ESG risks when assessing the overall condition, the prospects and the stability of a business. And this is not just at the outset of the initial lend, but throughout the monitoring stage, during the life of the loan, and potentially if investors are looking at investing in a restructuring scenario. This change in attitude is probably partly driven by the fact that financial institutions are themselves being subject to more stringent ESG disclosure requirements and therefore are having to scrutinise their lend portfolios to ensure that they meet the required disclosures properly. Could we go back to the previous slide with the graph? That's okay. Yeah, brilliant, thanks. So I think that this change in attitude is nicely captured in a recent survey of mid-market private equity investors carried out by Grant Thornton, where one of the questions asked was which factors are impacting your assessments of business value. As you will see from the graph, it's quite clear that the current interest in ESG factors are now strongly embedded in considerations by investors. And although it was noted that the percentage of time spent on ESG considerations compared with other factors when considering an investment is slightly less, the consensus was that it would gradually continue to increase, as it has done over the past couple of years, as the profile of ESG rises on everyone's agenda. If we go into the next slide, so how does all of this impact on companies and the business themselves? I think that there's a growing recognition that ESG considerations may pose material risks to businesses and adversely impact the credit quality of the business. For example, the results of one of Grant Thornton's recent Business Outlook Tracker reports, just to clarify, I'm not on commission for Grant Thornton today, second time I've mentioned them, was that 90% of the 601 business leaders surveyed said that assessing relevant ESG considerations made their business, one, more attractive to investors, two, improve their ability to obtain funding, three, increased the overall value creation of their organisation. All of which are relevant and integral to any successful restructuring. So it's clear that ESG risks could potentially affect exit prospects or strategies in a proposed restructuring, which, as I said earlier, may typically involve restructuring the balance sheet and bringing in new finance or investment, or doing for a debt for equity, and at the same time carrying out an operational restructure where part of the business is being carved out and assets are sold to repay part of the debt. This is exactly where businesses will need to plan ahead when they are putting together the restructuring plan with their advisors, i.e. lawyers and insolvency practitioners, and take into account the fact that lenders and investors will have ESG diligence requirements. And this could adversely affect the valuation of the assets, which in turn could potentially mean that a deal doesn't get done at all because the realisable asset value or investment value can't be achieved. So it's imperative that the ESG considerations form part of any planned restructurings at an early stage, I think. So given all of the above, I think the overall message to companies is to get ahead of the curve, put in place your ESG infrastructure, get the right people on board to do that, and to help you implement the ESG strategy before it all becomes mandatory through regulation. If you apply ESG principles in your business, it will give you a better chance to get funding and maximise the value of the business, which will be essential, especially in a distressed situation. Just to finish off this section with COP26 and everything else, climate change is at the forefront of the ESG movement, but I think a good example of how the social and the governance aspects can affect a business is Brewdog, who can't seem to keep themselves out of the press this year. You may remember back in the summer, the headlines were that the former staff accused Brewdog of effectively mistreating its employees. The quotes were misogyny and a toxic attitude to junior workers and culture of fear. So how did they respond to that? They put a lady on the board. They introduced a set of policy changes, introducing exit interviews and an employee representation group. This is just an observation, but it may be that these changes were encouraged by the US private equity investor that owns a minority stake in Brewdog. In fact, I think the lady they put on the board was a managing director of the investor entity. So again, perhaps an example of investor influence. Next slide, please. Moving on, I thought we would talk a wee bit about what the current ESG landscape looks like. In terms of the regulatory side of things, don't worry, I'm not going to start reeling off sections of various regulations because there aren't any yet. The precise nature and scope of ESG regulation in the UK continues to develop, and there are emerging regulations and reforms designed to help meet climate change targets and other ESG matters underway, which will most likely follow the EU equivalents on things like disclosure and reporting. Just a little mention of the UK Green Taxonomy, which in short is a common framework setting the bar for investments that can be defined as environmentally sustainable, which will be helpful for companies and lenders alike, as there's no definition currently. This is due to be in place by the end of next year, I believe. In terms of sectors, it's really the real estate and the social housing sectors in particular that are leading the charge in the ESG movement, at least under the E part of ESG. And this is where we are seeing a lot of the ESG-based loans and investments being completed. And Elaine will touch on that in her section later on. In terms of what finance is available, the terminology can be quite confusing, but essentially we have loans and investments that fall into two camps. In one camp sits the true green financing, green bonds, social bonds, sustainability bonds, where the proceeds of the loan must be, or in the investment, must be exclusively applied to eligible environmental and or social projects. So we're talking about renewable energy, energy efficiency, clean transportation, responsible waste management projects here. In the other camp, you have sustainability linked loans, which don't have to be used to fund green projects and are typically used in the real estate and social housing sectors for general corporate purposes and working capital. But the aim still is to facilitate and support environmentally and socially sustainably economic activity. Quite a tongue twister there. The defining feature of these sustainability linked loans is that the terms incentivize the borrower to improve its performance against certain predetermined ESG criteria. In practice, what this means is that the pricing on the loan is directly linked to the sustainability performance of the borrower. So put simply, if sustainability performance targets, SBTs, are achieved, the borrower pays less. And this normally takes the form of an interest rate reduction operated via a ratchet mechanism. But I've also heard of some provisions where instead of getting the benefit of an interest reduction, part or all of the margin saving is to be donated to charity or to be reinvested into sustainable initiatives. And if there's a failure to do so, the margin ratchet mechanism freezes until that's done. On the flip side, if there's a failure to meet any of these SPTs or to make any of the agreed disclosures or reporting requirements, the consequence is purely economical. It usually triggers a hike in the interest rate. It doesn't result in an event of default or draw stop for now, maybe. Another common feature is that if a matter is in dispute or a verification of any SPTs or KPIs are required, then it's typical to have a mechanism to defer this to an independent third party, such as an auditor, an environmental consultant, or perhaps an independent ratings agency. So I think it looks like the role of the independent third party will become increasingly important, especially to counter any greenwashing and the overstating of green credentials to get better loan or investment terms, for example. So in terms of documentation, although we don't have a standardized set of loan documentation or clauses to incorporate ESG criteria, clearly from what I've said, there are common features that have become practice. But the LMA, which is the industry body for the syndicated loan market, is helping to standardise various documentation and clauses to support ESG lending. So we are all waiting with great anticipation for this to happen. I should also say that for non-financing transactions, commercial transactions, M&A transactions, there's also the Chancery Lane project, which is a collaboration of a number of law firms around the world, including us, Brody's, who are developing climate and net zero style clauses. And these are readily available and even better, free on their website. Okay, next slide, please. To finish up, you'll be glad to hear, I thought that I would provide some food for thought about the future ESG landscape and gaze through my Mystic Meg crystal ball. I think I just gave away my age there. We may see a requirement imposed on companies to make specific ESG risk disclosures, for example, in their financial accounts. But companies should already be doing that anyway if there are any ESG risks, which are material uncertainties that could affect the company's ability to continue as a going concern. So that should be a caveat on the statement. In terms of the loan docs, we may see additional covenants to specifically address material ESG risks. Or lenders may just rely on the regular compliance covenants to cover ESG if and when the regulations come into play. I think that's probably more of when they come into play. If there are additional ESG covenants, lenders will need to decide how to deal with ESG breaches. For example, will they constitute an event of default triggering repayment of the loan? It may be that ESG influence may eventually be seen in a lender's credit decisions for a refinance in a distress scenario. It may be that restructuring negotiations could be the next opportunity to embed ESG positive changes, given the increase in recognition of the link between ESG and credit risks. Debt restructuring could also serve as an opportunity for lenders to encourage ESG positive changes to align the borrower more closely with current credit requirements and risk assessments informed by ESG issues. For example, where ESG risks materially affect or could materially affect the business's performance, cash flow and value, lenders could require that the ESG risks are taken into account in the company's business plan and financial model, which are typically the things looked at to assess the risk going forward as part of the lender's assessment of whether it will support a debt restructuring or not. Another thing that lenders could introduce is for ESG to be taken into account in CapEx and disposals. For example, they could introduce incentives for companies to get rid of any, less clean products, as it were. Claims litigation, could there potentially be an uptick? Perhaps there could be contractual claims for failure to meet sustainability performance targets, which trigger the interest rate provisions, as I talked about before. There could be a disagreement as to whether the SPTs are met or not. Greenwashing, where green credentials are found to be overstated. Potentially, an investor could seek to recover damages on the basis that the asset has been missold and the price inflated. I should say that's just an idea. It's not actually something which we have seen pursued currently. You never know, though. Claims against directors for breach of duties for failing to take into account ESG considerations in their decision making, potentially, in a breach of duties or wrongful trading action. This could be thrown into the mix to support such claims. Could even be claims against banks for providing financial support behind fossil fuel projects. Who knows? Just to close off very quickly, you'll be glad to hear, final point, transition funding, what about that? Could there be financial support for companies who are trying to get themselves ESG ready before things become mandatory? Obviously, this could be a costly exercise. Will the support come from government, from lenders? Probably both. Okay, that is me. Just some food for thought. I'll hand over to Elaine just now, who will tell us what her experience of ESG is in the real estate market. Thanks, Elaine.
Thanks, Shirley. And if we could move over to the next slide for the real estate section. Thank you, that's great. So morning, everybody. As Shirley pointed out, I think it's fair to say that the real estate sector probably has been more on the front foot in terms of ESG, but probably the primary focus previously has been in relation very much to the energy efficiency of buildings. And that will be relevant when disposing of distressed assets. So I am going to come on to talk about the regulations which we have in place relating to energy efficiency in Scotland, and also just some subtle differences between those and the position in England shortly. But to start off, I just wanted to talk a bit about how ESG in the real estate sector really has become more wide-reaching than just energy efficiency. And this is expected to continue to grow as a key area of scrutiny. And as such, it's going to be a consideration for those who are disposing of or looking to provide funding to distressed businesses which hold property. So as you can see from the slide, when looking at a building, ESG can cover a really wide range of elements, from things like energy consumption, land contamination, to the amenities which are available to the occupiers, such as transport links and the recycling facilities, and also to the extent to which tenants and occupiers are expected and engaged by the building owner to contribute to ESG implementation and improvement. And when thinking about ESG specifically in a real estate context, it is worth keeping in mind two things. Firstly, that property by its very nature is fixed in location, so any ESG targets will need to take into account the actual bricks and mortar element and the fact that it is a tangible asset. And secondly, that real estate does tend on the whole to be a longer term investment compared to other investment classes. So due to both of those factors, there is the real potential in the real estate sector to implement ESG strategies and to demonstrate progress. However, the flip side of that is it's likely to be evident where there has been very little consideration given to ESG implementation or where there are key deficiencies. So if we can move on to the next slide, please. I'm just going to take a look at how ESG in a property context may apply to a distressed business seeking further investment or funding, or where a property is disposed of as a result of enforcement action. Now, as Shirley touched upon, the first stage that a buyer or investor or lender will have to go through when looking at a distressed business and deciding or whether or not they're happy to proceed. If it is a property-based business or there's property involved, they're going to be looking at those underlying properties or the portfolio of properties. So when there's any kind of pre-restructuring review being undertaken, what we may start to see is that there's some kind of initial ESG stress test being undertaken to really check whether there are any initial red flags relating specifically to the building. So for example, things like, are there any major regulatory fines for non-compliance at the building outstanding? Are there potential remediation costs for land contamination? And also kind of softer reviews, such as looking at tenancy schedules to check if we've got specific tenants of concern in occupation. So for example, are there tenants who are carrying out activities which may be considered controversial or may just not sit well with a potential buyer or lender or investor in terms of their own ESG objectives. So that initial review could helpfully act as both a financial screening exercise to identify possible liabilities in relation to the property, but also to kind of sense check any potential reputational issues which may further arise down the line. The next stage of the transaction will be the due diligence process, and that's going to be a more in-depth review to identify, for example, if there are any legacy issues at the property for non-compliance. You would normally expect at that stage to see third-party searches or surveys being obtained in relation to ESG issues, especially if there's known issues such as potential flooding concerns or issues regarding the energy effectiveness of the building. And at that point, there's likely to be some kind of assessment as to whether any improvements could be made going forward and what the cost of implementing those will be. Now, that's going to depend on whether the property is a new development where the opportunity and quite probably the expectation to achieve a higher ESG standard is there compared to, for example, the renovation of an existing building, where it's possible that the ESG gains are going to be likely more on an incremental basis. So the due diligence stage is really the point when any ESG concerns will be aired in respect of the property. An assessment may be need to be made as to how those will impact on any targets that are being set and what the proposed action points are going to be going forward. Now, this will be important in a distress context in terms of determining the likelihood of future costs and the resources which would be required to ensure that the building is ESG compliant. Now, in a restructuring scenario, there's likely to be an increased focus on how the property is actually being managed on the ground. So who's been responsible for day-to-day ESG compliance, and have any of the other tenants or occupiers been engaged in that process? So what we may see is that buyers, investors and funders are going to want to look at, for example, how are the operational costs of the buildings affected by any ESG issues? Are there any concerns in relation to potential future liabilities and claims at the building? And has the property owner been kind of staying on the front foot in terms of compliance to ensure that the building does not become obsolete where kind of previous recommendations then become mandatory? It may also be useful to understand if there has been engagement with tenants on ESG matters to try and impact on their behaviour, for example, how they consume energy at the property, whether they're using the recycling facilities available. And we are increasingly starting to see building owners implement more practical initiatives such as, for example, kind of good practice tenant handbooks, or actually offering up training to their occupiers as to how to effectively use different facilities within the building. So when it comes to an enforcement and distressed disposal scenario, the benefits of having the building being managed in accordance with good ESG practice is that it may become easier to attract new tenants. So arguably less incentives would need to be offered up to secure rental income. It may be easier to manage any voids in the building as tenants may be more satisfied with how the building operates and the facilities available, so they'd be keen to extend lease terms rather than looking for alternative premises. And there may also be a willingness just simply to pay a higher rent for what's considered to be a green property. So where an insolvency practitioner is stepping in to manage a property, it would be worth checking whether there are any ESG clauses within the lease which set out how the landlord and tenant will cooperate with each other on ESG matters. So for example, how are capex responsibilities and cost savings shared between the parties? And if there's any kind of commitment to each other in terms of considering any ESG factors. So for example, when you're appointing contractors such as cleaners, etc. So the anticipated benefit of all of this is that if any potentially material ESG issues have been identified and managed at each of the earlier stages, then that should arguably result in a reduced risk of any kind of price chip and enhance the value of the property on ultimate disposal, which is obviously relevant for gathering funds in a distressed situation. And similarly, if key performance indicators have been tracked from the start, then any improvements can be evidenced, and that will assist in also instilling confidence in a buyer or a future investor that the property has been well managed from an ESG perspective. So if we could please move on to the next slide. I mentioned that really the focus to date in the real estate sector, both north and south of the border, has been in relation to energy efficiency. And I thought it would be useful just to touch upon what the energy performance certificate position is in Scotland, because there are some subtle differences. So I've set the relevant legislation out on this slide, and since September 2016, owners of large commercial properties in Scotland are required to meet certain additional requirements when they sell or let properties. I'm just going to focus on commercial properties here because we're obviously quite tight for time, but it's just the reason for mentioning this is these requirements still require to be met in a distress scenario, so they will be relevant in a restructuring. So most people who've had any a property transaction will have probably come across an EPC. It stands for an Energy Performance Certificate, and it shows the environmental impact of the building, and it's calculated by measuring the amount of CO2 that's estimated to be released from the property. That measurement is known as the Building Energy Performance Rating, and it's graded on a scale of A to G, with A being the most efficient and G being the least efficient. The EPC will also include what's known as a recommendations report, and that identifies a list of measures for improving the energy efficiency of the building. However, it's just worth bearing in mind that the recommendations report is just that. It's a recommendation and it's not mandatory for an owner to carry out those works. However, that differs from an action plan, which we also have in Scotland, which I'm going to just come on to mention. As I mentioned, an EPC is required for non-domestic properties in Scotland where it's sold or let to a new tenant. So this requirement will equally apply to any dealings by an insolvency practitioner or a lender disposal as well. Now, in addition to EPCs in Scotland, owners of large commercial properties also require to produce a document which is known as an action plan. So if you've been regularly dealing with properties in England, you've maybe not come across this before, but an action plan will set out the carbon and energy savings that the property will achieve if works are carried out. And owners then have to choose whether or not the energy efficiency of the property is to be monitored and reported annually, or whether these works will actually be carried out to the property to improve the energy efficiency and reduce emissions. So regardless of which option is chosen by the owner, some kind of action is required, whether it's to actually do the works or to comply with the monitoring and reporting obligation. So it is a positive obligation either way. And an action plan is required where it's a non-domestic building with a floor area of more than 1,000 metres squared in area, and which does not comply with the 2002 Scottish Building Standard regulations. So it is possible that you may need to also engage a technical advisor if it's not apparently clear whether or not an action plan is required. So I appreciate that's all quite a lot of kind of legal and kind of technical jargon. So what does it mean in practical terms? Well, if the building's covered by the regulations, an action plan is going to need to be produced by the seller or the landlord, and a buyer or tenant must be aware of the contents. Now, there's no exemptions for an insolvency practitioner or a lender disposal. So if an action plan is required under the regulations, it will still be required in a distressed disposal. Now, as part of a restructuring review, it should you should try and determine whether or not an action plan is going to be required or whether one is already in place. if there is one already in place, you need to establish whether it's been elected that the works would be carried out and where are they in the stage of that process of doing those works, or was the election simply to monitor and report the energy efficiency of the building, and has that obligation been complied with? What you might find is that a buyer or a funder may look for some of the essential improvements referred to in the action plan to be carried out, and that will be part of the commercial negotiations. So it's definitely useful to establish the action plan position at the outset. Although an action plan is not strictly required by the legislation for a standalone financing, so for example, where there's no associated property purchase, we are finding that funders will still ask for one as part of the conditions of their loan, because they really want to get comfortable as to the action plan position and to know the EPC rating. So we see those regularly as being conditions precedent to loan. So you would be fully expecting that if there is a lender involved. And really what all these parties are wanting to know by seeing this information is they want to be able to take account the costs of carrying out improvement measures or implementing the monitoring and reporting obligations when pricing the property. So it is relevant in terms of the whole valuation process. So just to finish briefly on EPCs, I thought it was just worth mentioning that the energy performance system in England and Wales is very similar on the face of it to what we have in Scotland, but there are a couple of key differences. So if you're dealing with property regularly in England, it's just worth bearing that in mind. So under the English regulations, it is unlawful for a landlord to lease a non-domestic property where the EPC rating is either an F or a G, so those are the two lowest ratings, until they've taken certain measures to improve the energy efficiency of the property. And that's regularly referred to as the minimum energy efficient standard, or MEES for short. You maybe heard that referred to. It's just a flag, we don't have that same restriction in Scotland. So even where you've got an EPC rating, which is an F or a G, you can still let the property. And also the English regulations also apply to lease renewals, whereas in Scotland, it's just in relation to an actual new letting of the property. So arguably the system in England and Wales is more onerous than in Scotland. However, just quite often what we find on funding transactions or acquisitions, which also involve English properties, is lenders and buyers are still quite nervous about low EPC ratings in Scotland because they're used to dealing with the English system, and they also tend not to be that familiar with how action plans operate as well. And just a final point from me, it's just worth mentioning that at the moment, the Scottish regulations for an action plan apply to buildings that are larger than 1,000 metres squared. However, there is a focus in Scotland on the environmental impact which property has. So it is possible that that threshold may be reduced in the future. So if you are dealing with a property in Scotland and you need any advice on an EPC or action plan, it's worth just checking in to see what the requirements are at that time. And it's definitely one that may move in the future. So that's a bit of a roundup on what we're seeing in the real estate market at the moment. I'll pass back to Lucy, who's going to just do a bit of a roundup and close today's session.
Thanks, Elaine, and thanks, Shirley. I guess, bringing what we've heard this morning together, I think that what the session really has highlighted to me is the wide scope of ESG and the practical ways in which it could actually impact on restructuring scenarios, both now and in the future. And kind of drawing some of the things that we've heard this morning from both Shirley and Elaine, I guess it's that on the practical side, what we see, on the lender investor side, what we think is that you shouldn't underestimate the lender or investor's attitude towards ESG, as it will have a practical impact on the funding that you can achieve, and it will also impact on the value of the business and its assets. Companies who show and give proper thought now to their ESG credentials may be in a position to get ahead of the curve and will be on the front foot rather than waiting for regulation to dictate to them how they should be dealing with ESG considerations. And just kind of picking up from what Elaine had said on the real estate side, the expectation really is that ESG will continue to be a focus in the real estate sector going forward, and it's not going to simply be restricted to issues of energy efficiency. Funders and buyers are scrutinising the EPC documentation, and as part of any proposed restructuring involving property, you're going to need to check what the ESP position is very quickly, depending on how you're wanting to dispose of the property, and actually more importantly what your plan is for the business. So it's something you will need to be aware of and have potentially in your kind of pre-appointment checks. If you can get the information at that stage, it would be particularly beneficial. And then thinking about the subtle differences between the EPC regimes north and south of the border, they're likely to continue to evolve. So again, it's just something to consider if you are doing work UK wide. So hopefully you found this morning's session helpful and has given you a bit of insight into some of the things that we have seen. We've had a few questions in, so let me just deal with those because we've got time to deal with them. Shirley, just one for you. So,
well, thanks.
Do you think that ESG loan terms will ever be an event of default under loan documentation?
Yeah, I have 3 minutes. As I noted before, currently the penalty for not meeting sustainability performance targets is purely economical, in that the only results that the borrower pays more interest. There's no default, no draw stop, and I think probably we won't see the failure to meet any of the ESG terms become an event of default on the basis that businesses need a degree of operational flexibility, and if you have an ESG event of default trigger, that could be counterproductive. And I guess the defining feature of a sustainability linked loan with the margin ratchet mechanism is to provide a carrot and not a big stick. Actually, what I think will happen is that lenders will rely on other covenants and clauses that get you to the same place. For instance, if and when the ESG regulations come into play, I think the lenders could rely on the regular compliance covenants for an ESG trigger. There's always the MAC clause as well, but we tend not to rely on that to establish default, as there's always room for dispute as to what is material or not. Mm-hmm. So just my thoughts on that.
Yeah, no, that's helpful. I think that in terms of the question, from a kind of a litigation perspective, I think you're quite right that if there's not very defined or measurable ways in which to ensure compliance with ESG issues, then it may be more difficult to enforce ESG clause in relation to default, and certainly kind of financial default is nice. It's quite a bright line, and normally is fairly clear cut, whereas if there is any kind of dubiety or ambiguity in relation to measurement, then that could be difficult and tricky in relation to a default scenario. But it may be depending on the lender. So if you are somebody who is, only does green financing, then it may be something that you'll be looking at quite closely towards your loan documentation. Elaine, you're not out of the woods. There's a question here for you as well. So in terms of the EPC certificate, you've explained a bit about that when you're granting a new lease. If an IP was granting a license, would they need to issue an EPC certificate? Quite a technical one.
I'm just glad I didn't get the event of default question. So I think the thing to remember in Scotland is there's these two elements if the building meets the criteria. There's getting the EPC itself and then the requirement to get the action plan. So I'll deal with the one that I do know the answer to first of all. The action plan, there is an exemption for short-term lets. So you need to check the period of that, and I can't remember that off the top of my head. I think it's about 16 weeks, and that makes sense because if you don't go and get an action plan, it then triggers these positive obligations that I mentioned about having to either do the works within a period, or then it starts the monitoring and compliance. So I think the reason that's been excluded from the legislation is so it doesn't trigger that obligation in a short-term situation. From memory, there are exemptions for when you don't need to get an actual EPC. I don't think there is one for short-term lets off the top of my head. I think the wording in the legislation refers to like prospective tenant and letting. So they've left it probably deliberately quite vague. So I think what you would need to do is, if a license is being granted, I think you'd need to look at it on a case-by-case basis as to what, you know, how long it's likely to be in place, what it's being used for, etc. So definitely one to consider. The just last point on this that probably is quite helpful is EPCs do last for 10 years once they're obtained. So you might find that there's actually already one in place, and there is a public EPC register which you can do to search against to see if there is already one for the property. So you might find in practice it's actually a bit of a non-point in that there might already be one for the property that's still valid.
Yeah, well, that's really helpful. I'm sure that people will think that's a really good practical tip. So thank you very much. And I'm just conscious of the time, so we'll wrap up there. And I just want to thank you both for your contribution this morning. And thank you all for joining us. If anybody does have any questions or queries or just wants to chat to us about any of the issues that we've talked about this morning, then our details are there, and we'd be delighted if you would get in touch. And the final point is the survey at the end. So if you would take a minute just to fill that in, that would be very helpful for our marketing team. Thank you very much, and I hope you all have a lovely day.